There is a line running straight through the trading mentor business, and most of the people selling on either side of it have no idea exactly where it sits. On one side is education, teaching how markets work, explaining a strategy in general terms. That activity is largely protected. On the other side is personalized investment advice, telling a paying customer what to buy, when to sell, pushing specific signals into their account. That can legally require federal registration as an investment advisor or a broker. So we audited the regulatory line every paid trading mentor operates right up against, and how you can check before you pay whether yours is actually registered. Start with the law that defines the line, because it is older and narrower than most people assume. The relevant statute is the Investment Advisors Act of 1940. Under the Securities and Exchange Commission's own long-standing interpretation, a person is an investment advisor if they satisfy three elements at once. First, they give advice about securities, their value, or the advisability of buying or selling them. Second, they are in the business of doing so, a regular activity, not a one-off remark. And third, they do it for compensation. Notice what is not on that list. The statute does not require that you call yourself an advisor, hold a license, or even manage anyone's money. If you are paid regularly to advise people about specific securities, all three boxes are ticked, and the law may consider you an investment advisor whether you intended it or not. Now, the protection most education sellers are leaning on, whether they know its name or not. The Advisors Act carves out an exclusion for the publisher of a bona fide newspaper, magazine, or financial publication of general and regular circulation. In 1985, the Supreme Court tested that exclusion in Lowe versus the Securities and Exchange Commission. The court ruled that genuine impersonal publications distributed to the general public on a regular schedule, not tailored to any one subscriber, fall outside the act entirely, partly on First Amendment grounds. That is the shield a real trading newsletter or a general course stands behind. But the reasoning is also a map of where the shield ends. It holds only while the advice stays impersonal and general. The moment the relationship becomes personal, advice attuned to one subscriber's portfolio, a back and forth like a traditional advisor and client, you have stepped out from behind it and into the act. So picture the line concretely. A recorded course explaining how options work, sold to everyone alike with no personal guidance, is general education on the protected side. Now walk toward the line. A signals group pushing specific buy and sell calls on named securities to paying members is advice about specific securities for compensation as a business. A mentor who reviews your individual account and tells you what you, personally, should trade is giving personalized advice. And a coach who actually places trades in your account or pools members' money to trade together is past the advisor line entirely. That conduct can trigger broker-dealer registration. The pattern is simple. The more personal the advice, the more specific the security, and the more it touches your actual account, the further across the line the seller has walked. This is not a theoretical line, and the regulators have been walking it forward for years. In 1985, the Supreme Court drew the boundary in the Lowe case. For decades, it mostly governed printed newsletters. Then social media collapsed the distance between a publisher and a one-to-one advisor, and the regulators noticed. In 2024, the Securities and Exchange Commission and the Financial Industry Regulatory Authority both publicly flagged finfluencers as a registration concern, and the Commission's own Investor Advisory Committee issued a formal recommendation that same year. Brokerage firms paying influencers to drive signups got hit. The brokerage M1 Finance settled for $850,000 over failures tied to influencer promotion, and TradeZero America settled for $250,000. And into 2025 and 2026, enforcement against unregistered advice sellers kept climbing the priority list. The line has not moved. The number of people standing on the wrong side of it has. Consider what crossing the line actually costs, because the numbers reframe the calculation. When the Commission finds that someone acted as an unregistered advisor or broker, the penalties are not symbolic. In one 2025 settlement, a firm found to have acted as an unregistered broker agreed to give back $594,000 in disgorgement, plus roughly $77,000 in interest, plus a $150,000 civil penalty, on top of a censure and a cease and desist order. Disgorgement claws back the money earned, the penalty is the fine on top, and the cease and desist order can end the business entirely. If the Commission rules the activity required registration, the math inverts. Years of subscription income can be ordered handed back, with a fine and a shutdown stacked on top. The line is cheap to cross and expensive to have crossed. Here is the part that actually protects you, the buyer, and it takes about 5 minutes. Registration is public, and 2 free government-backed databases tell you what a sales page never will. The first is BrokerCheck, run by the Financial Industry Regulatory Authority. It shows whether a person or firm is registered as a broker, their work history, and any disclosures, customer complaints, regulatory actions, or disciplinary events. The second is the Investment Advisor Public Disclosure Database, known as IAPD, which covers registered investment advisors and their representatives. Search the mentor's real legal name and their firm in both. If they are registered and clean, you at least know who you are dealing with and that a regulator can be called. If they carry disclosures, you read those before you pay a cent. And if they are selling personalized signals and account guidance for money but appear in neither database, that gap is the single most important fact about the product, and the one the marketing will never mention. So where does this land? A paid trading mentor is not automatically breaking the law. Genuine, impersonal, general education has stood on protected ground since the Supreme Court said so in 1985. But that protection is a narrow shield, not a blanket, and it falls away precisely where the money is best, in personalized advice, in specific signals on named securities, in anything reaching into your individual account. That is the zone where the Investment Advisor's Act's 3-part test bites and registration can be required. So carry one filter into every trading mentor sales page. Not whether they are confident or whether their screenshots look good, but this: is this general education or personalized advice for compensation? And if the latter, are they registered? Answer that yourself for free on BrokerCheck and IAPD before any money changes hands. The mentor on the right side of the line will survive that search. The one who isn't is the whole reason the search exists. Audit closed.